Hi everybody, Mark Daly here, immigration lawyer with Pro Forma Immigration Attorneys. This is our third video in this series, how to get a green card for your spouse, right? U.S. permanent residency for spouses of U.S. citizens. A step-by-step guide for USCIS immigration forms and documents. And this one is the 485 application to register permanent residence or adjust status. This form, we're going to be going through it, and we want you to check in on this one. This is the third of 7 in this series. So for me, the step-by-step immigration forms is a way for me to do low-cost form and document review for my clients who want to save some money on an immigration case and fill things out on their own. We also have Pro Forma Immigration Attorneys because we want to also provide full service representation for clients in a wide range of immigration cases. But this one here is mostly step-by-step immigration forms where you're going to fill in your own forms, you'll bring them to us, and then we'll review them over the course of 2 hours to make sure everything's done properly. I also do immigration law training for other lawyers who are in criminal or family law or bankruptcy and they want to start up an immigration practice. So I help them with that as well. And that's what I do in immigration. I love immigration. I've been doing it a long time. And, I present at conferences. I'm a member of the California Bar, and I'm also the member of American Immigration Lawyers Association. Now, I'm going fast on this because I really don't want to take too much of your time, but it's hard because it is so deep and it's so complex. This form, the I-485, is a very significant form. So we're going to dive into the terms here. Petitioner is the U.S. citizen in this case who's sponsoring. Beneficiary is the immigrant. Also, the applicant is also the immigrant. So those are the words. Permanent residency, green card, means, they both mean the same thing. An adjustment of status is what this form does. And it's when you want to apply for a green card in the United States, applying in the USA, as opposed to applying outside at an embassy, which would be consular process. So those are the terms that we're using here. So what we're doing, we are talking about downloading your forms first, then getting your documents together, getting your information together, filling out the forms, assembling and filing your documents, and then going to an interview. This is the process by which U.S. citizens sponsor their spouses here in the United States to get green cards. So this is what we're doing. We're at the fill out forms part, number 4 here. So the spouse adjustment of status. Here we are. We go to the forms, go to the website, uscis.gov, and you're going to look at the I-485 application to register permanent residence or adjust status. We're going to look at the USCIS website info on the form, and then we're going to look at the form instructions, and then finally we're going to dive into the form itself, the fillable form, and show you how to fill this baby out. All right? So we're going to go switch over now to screen capture of the USCIS website. Okay, so you start on your browser, Google, whatever, and you go USCIS, and that's where we're going to the USCIS GOV homepage. There's all kinds of scammers and different websites and fake stuff, so you want to make sure you're getting the real deal. You're going to get notices and stuff about the USCIS offices closing temporarily for coronavirus. I have an interview that we've been closed out, so we can't do that. And so we go to the forms, which are up here, forms, and then scroll down, and you're going to go with alphabetical and numeric. So I, and then 485 right there. We got the form details over here. If you click on this, you'll get a little notice, and you want to read these notices. They're regarding, in this case, a lawsuit that's being filed regarding the affidavit of support, the new affidavit of support requirement. So with immigration law, there's a lot of case law that impacts immigration law, and it's hammered out in the courts. So it can be really confusing on knowing what you're doing. All right, so let's go back up to the form details. And again, more notices, final rules. and then the form itself right here, I-485, instruction to form I-485, and then the e-notification. There's also these little drop-down menus here that have information. Number of pages, the edition date, 10/15/19. You can find the edition date at the bottom of the page for the form and instructions. So any edition before this will be rejected. So that's why you always want to look at the edition date. Where to file. They have a link to the filing addresses to form 485, and it's based on, the type of thing you're doing. You are applying for adjustment of status under the following eligibility categories: spouse of a U.S. citizen, so you're going to be filing over here. This kind of information is found in the filing tips, filing addresses. All right, where to file. Now, filing fee, okay? There's going to be a link to, or a drop down here where here's how to pay USCIS fees. You can do credit card authorizations, and then how to pay with a check and what it needs to say on the check. So that's all here. And the amount of fees, though, is determined by what you're doing. So under 14, ages 14 through 78, these are most of my clients. Form fee is $1,140. Biometrics, which is the fingerprints, is $85 on top of that, so it comes to $1,225 for this form, for the I-485. And this is going to be in addition to the I-130. We just did the I-134, and it had a filing fee of like $530. So those will be totaled together. And then let's see what else. Checklist of requirements. View the checklist of required initial evidence. It's nice to see these. So checklist of required initial evidence for Form I-485. Don't submit the checklist with the form, right? But we have a list of stuff. We've gone over two passport style photographs, government issued identity document, birth certificate. All the stuff we've talked about are here. And if it's an employment-based form, we've got another checklist and a special immigrant juvenile and different checklist. But these are nice to have. Just to double check that you're not forgetting anything, because you don't want to get stuff kicked back for not providing it. All right, so checklist, then we go back to special instructions. All right, the supplements, Liberian nationals, filing form 765 and I-131 with form I-485. We're going to be doing that. So here's the links to those forms and some more information on there. Which a box to check, premium processing, just different information, and then related links. All right, so there's more information down here. And we're going to go on now to the instructions. Okay, the instructions. I like to save the instructions on my hard drive with the forms so I can document what the instructions were on a day. Because the law said we have to follow these instructions that they publish. So it's important to reference these just to make sure you're doing it right. Okay, so what's the purpose of Form I-485? That's a good question. I-485, application to register permanent residence or adjust status, is used by a person in the United States to apply for a lawful permanent resident status. Throughout these instructions, we'll sometimes refer to Form I-485 as an application for adjustment of status or as an adjustment application. Right? We talked about adjustment of status as the process of getting a green card here in the United States. Who may file? Okay, so we have a principal applicant. And remember we talked about the applicant and the beneficiary, right, in our marriage-based scenario that we're working with. And that's because this 485 is an application, so it's an applicant filling out the application. Right. And derivative applicant, if I was a U.S. citizen, I was applying for my spouse and they had children, I have stepchildren, then those derivatives would also need one of these applications. There's other immigrant categories as well who may not be eligible to adjust status. So it talks about bars, and this is the thing about with the adjustment with the green card application. The petition was proving the good faith marriage. Adjustment application is proving there's no bar to your green card. And you've got to prove that. You have to show them that there's no bars. So you have to anticipate what all the bars are, and you have to give them evidence on every bar. If you can't show evidence that you're not subject to one of the bars, then they hit you with the bar, and you're barred. And so that's how the presumption works, that you're barred. And then the burden of proof, the amount of evidence you have to give them, is 51%. That's what the law says. In my experience, reality, you got to give them a lot more than that. They're looking for like clear and convincing evidence, like 85, 90% on each one of these bars. So it's very unfair in that way. But we're talking about the bars. It's beyond the scope of this. If you think you've got a bar, they're going to ask you all these questions on the form to weed out the bars. So if you think there's a question about one of the bars, then you would call a lawyer and give them the story and let them do the research, case history, and just, find out if there's going to be trouble for you coming down the road. Grounds of inadmissibility. This word inadmissibility is what we're talking about, because in the law, this is what's written up. They call it grounds for inadmissibility. And then exchange visitors, J1s or J2s, A, G, and E. There's just problems if you have these kinds of visas with getting a green card. The principal applicant, derivative adjustment applicants, okay, getting more information on that. And then here we go into the general instructions and biometric service appointment. There was something here about the G325A. Form G325A is no longer required. I've been doing these videos for so long. I have G325A videos. They're not required, so don't pay any attention to those. Here's the filing fee. Evidence support. We have to give all the evidence proving you're not barred to anything. The biometric service appointment is going to be required for you to take. Then we go how to fill out the form. Black ink, we know that. And like we've said before, if you have extra information, you go back to the end. And then NA or none is important. And all this stuff we've pretty much talked about in the previous video. Like the biographic information, all this stuff. So you don't really need to spend a lot of time looking at this. The evidence, we're going to be telling you what evidence there is. But again, if you have a ground of inadmissibility pop up, you're going to have to give a lot of evidence to prove you're not subject to that ground or that you get a waiver. So then you need photos, government ID, birth certificates, proof of your admitting into the United States, filing as a beneficiary of an immigrant petition. Then you need to show you've got a receipt for the immigrant petition, or better yet, what we're doing is just give your immigrant petition in with the 485, and that's going to cover that. Some don't require an underlying petition. That's great. Marriage certificate or another proof of relationship. So if you're a derivative applicant, submit a photocopy of the marriage certificate. So if I was having my brother petition for me and I'm now getting my green card, I'd want to give my marriage certificate of my spouse. But we're not doing that. We're talking about spouse to spouse. And evidence of continuously maintaining lawful status since arrival in the United States. In immigration relating to marriage, it's not so important to prove that you've been in lawful status. In fact, you can fall out of status, and if you are married to a U.S. citizen, you can still get a green card. So that's not the same for other categories like business-based green cards. If your employer is petitioning for you and you fall out of status, you may not be able to adjust status here in the United States. You may not get a green card. Here you have to probably go outside the country and get one abroad. Confirmation of bona fide job offer. Okay, we don't need that. Portability, we're not worried about that. Okay, public charge. Here's the new one. Declaration of self-sufficiency, Form I-944, and Affidavit of Support, Form I-864. All right. In addition to Form I-485, you must file 944 and 864 to establish that you are not inadmissible based on the public charge ground, meaning that you're going to be taking up benefits from U.S. citizens if you fall into one of the categories listed below. So we're going to be doing a whole video on the I-944 and 864, which is coming up, but they're giving you the heads up. There's a ground of an inadmissibility around these issues of public charge. Who has to submit them? So we'll go into this when we get into this form. But it's nice that they require it and they give you all the information here as well. But you can see there is a huge amount of information on these categories now. Report of medical exam and vaccination record. Well, yeah, they can bar you if you've got a bad disease and you don't want to cause a pandemic or a health problem in the United States. They can bar you for that. So you need a medical exam coming in and your vaccination record. Police and court records of criminal charges, arrests, and convictions. So certified police and court records. So the police, if you've been arrested, even if you weren't convicted of anything, police records are going to show the arrest. Then the court records are going to talk about, the conviction, the acquittal, or the probation, whatever happened in the court is going to be in the court record. And so you want that for all the criminal charges. And they ask you this question so many different ways. If you have been convicted of a crime or you've been arrested, you probably want to consult with an immigration lawyer to find out the evidence you would want to put in and then what you want to say in an interview, how you want to describe that. Very important. So there's all this information on the convictions. And then waivers of inadmissibility. Yeah, even if you've been convicted of a crime like possession of marijuana less than 32 grams, there is a waiver for that. So you might need to file a waiver, which is a pardon saying, I'm sorry, I did it, but it's going to be a real extreme hardship on my spouse if I'm not allowed to get my green card because of A, B, C, and D. You present that waiver, and then they'll decide the waiver to see if they're going to waive this ground of inadmissibility and let you get your green card. And that's a whole thing you probably want to talk with a lawyer about. And we do that as well. J1, J2, we're not working with that. Waiver of diplomatic rights, don't have to worry about that. Then we get into the lower stuff, the filing fee and where to file and this kind of boilerplate. All right, so now we're actually going to jump into the form. So back into the form here, I-485, opening, saving on my hard drive like that, and now filling it out from my hard drive and not from the website. If you have the website open, just close it, all right? So I'm going to bring this baby up. 485. Okay, when lawyers do it, you hit the box 28, G28 and you put your bar number there. Start here. Now the applicant might have an A number, and so if they do, go ahead and put that there. Now we've gone over a lot of these boxes already in the previous video for the I-130, so this allows me to skim through this stuff. Okay, so we'll be skimming and then diving in where it's applicable on the 485. So information about you, the name used since birth, okay. Other information about you, we're getting the basic stuff. Date of birth, gender, city or town of birth, all that needs to match your birth certificate, all right. Country of citizenship and nationality, A number, online account number, social security number. U.S. mailing address and care of name, only use that if you're living with someone else. If you have your own place, don't use it. Alternate and or safe mailing address. So if you're filing Violence Against Women Act and you want this to go somewhere else so that someone doesn't know that you're actually filing for this, then put that, and that would be an in care of name probably, and their address there. Recent immigration history. Okay, we've gone through that in the last form. And so then the next one is application type or filing category, right? I'm filing this form at 485 as a principal applicant, which is if I'm a spouse, that is going to be what I am. For my kids, if I were bringing my kids and getting them green cards, they would be filing and they'd be noting that they're a derivative applicant. But for the spouse, it's going to be principal. Attach a copy of Form I-797 receipt or approval notice for the underlying petition or the application as appropriate. We'll be giving the application. We're going to give the I-130 along with the 485. It's called a concurrent filing. All right. I'm applying as a principle based on, and you have all these categories that you can use, and we're using this one here. Immediate relative, spouse of a U.S. citizen, parent of a U.S. citizen, of U.S. citizens 21 age or older, and unmarried child under 21 years of age of a U.S. citizen, Form I-130. We're the first one here, immediate relative, spouse of a U.S. citizen. Got it. You have all the other categories here that we're not worrying about. Then there's human trafficking categories as well. Special programs based on certain public laws. Additional options. Additional alien worker. Okay. If you did an I-140 alien worker form, you would do this, but we didn't do that. So we're not going to put anything there. And then if you answered yes to item number 9A, did a relative file the associated I-140 for you? We're not answering that, so we're not going to be subject to this. No, skip to item number 10. Regardless of the immigrant category adjusting, do you hold VAWA? Are you a U? Human trafficking. These are the high priority programs here. 245I section. This is not a 245I application, which is someone who's entered illegally and they want to get a green card after entering illegally. Information about your immigrant category. If you are the principal applicant, provide the following information. Receipt number of underlying petition. We're not going to have one of those because we're filing an application along with this. Priority date from underlying petition, if any. Okay. If you're a derivative applicant, principal applicant name. You're tying this derivative application back to the principal. Additional information about you. Have you ever applied for an immigrant visa to obtain permanent resident at a U.S. embassy or consulate? Okay, yes or no. If you answered yes, then you give the information on that along with the decision. Your address history for the past 5 years. Okay, we know what that's all about. Employment history for the past 5 years. All right. We know what this is all about, and we know the importance of giving lots of employment history because they're going to rate you in this meritocracy on if you've got skills and education and work experience so that you're not going to take welfare when you come into the United States. You're not going to be a public charge. All this information is relevant to that determination, so put a lot in there. Then we go about your parents. All right, we've done this before. And then your parent two, information about that. If they're deceased, go ahead and in the current city or town of residence, put in deceased. Current marital status. This is an interesting question. If you're married, is your spouse a current member of the U.S. Armed Forces or Coast Guard? Right? How many times have you been married? Information about your current marriage and prior marriages. Okay, we've seen all this before at the I-130. Children. Okay, we've seen all this children information about the I-130, so we can just copy it right over from that. Biographic, we've already walked through this. All right. General eligibility and inadmissibility grounds. All right. This word inadmissibility. This is the thing that we're going to be looking at right now to weed you out and disqualify you and keep you from getting a green card. This question's interesting. Have you ever been a member of, involved in, or in any way associated with any organization, association, fund, foundation, party, club, society, or similar group in the United States or in any other location in the world, including any military service? So what I like to do is I like to, again, if you've been a member of any group that is doing good work in the world or a church that does stuff, you can list that because America likes people who are engaged in good, positive civic activity, right? Also, military service. So because we're a warrior culture, right, we value military service, so that's also something that you can put down here and score points. And you go and put the organization, city or town, nature of group, right? Now, if it's a terrorist organization, there's going to be lots of questions coming down the road about that. But for right now, I like to use this as a way to shine and show that you are a person who has a good history of civic responsibility and activity. Now we're getting into these other ones here. Answer items 14 through 80B. Choose the answer that you think is correct. If you answer yes to any question, or if you answer no, but are unsure of your answer, provide an explanation of the events and circumstances in the space provided in Part 14, additional information. There's a giveaway right here on how to handle this form. If you think you are unsure and you want to say no, you can say no and be unsure about something and provide more information. And that's going to be a little different from saying yes to a question. So there is a big distinction. Say yes if you know the answer is yes. If you're unsure, say no and then say why you're unsure. Don't say yes. Because yeses sworn are legally binding yeses. They're hard to undo. A no that you give with an explanation is easier to undo, easier to deal with legally. So procedurally, your due process is going to be preserved if you say no and then give an explanation around it. And if you have to say no to something, and with an explanation, you probably want to have a lawyer help you make that explanation, right? If you're saying yes to things, it's a sign you need to talk to a lawyer about your application. But let's jump through these. Have you ever been denied admission to the United States? Turned around at the border? That's what that is. Ever been denied a visa to the United States? So this is around at the embassy, consulate. Have you been denied a visa? Have you ever worked in the United States without authorization? Now, with our cases here, which are a spouse of U.S. citizen, if you work without authorization, that's not going to be a ground of inadmissibility for you. That's not going to bar you from getting your green card. That's not going to sink your ship. They're not going to weed you out because you've worked illegally before you've gotten married or even while you're married and now you're applying for the green card. So if you have worked illegally, you want to answer yes to this question. Have you ever worked in the United States without authorization? If it's yes, say yes. It's a freebie. They're not gonna hammer you for that. Now, if you lie and they find out that you're not telling the truth, then you're gonna be real deep in problems, in trouble, because now you got a misrepresentation on this form. You want to keep your form clean. You don't want to have any misrepresentations, right? So be clean with this. Have you ever violated the terms or conditions of your non-immigrant status? All right. And so that, again, that's not going to be a real problem for someone who's getting a green card based on marriage to a U.S. citizen. Are you presently or have you ever been in removal, exclusion, or rescission or deportation proceedings? Okay. That'll trigger them to pull the file. Also, if you are in, then the judge has to decide this case for you. So they're not going to go full into processing an answer or a decision in this case. They're going to kick it back to the judge. Have you ever been issued a final order of exclusion, deportation, or removal? Right. So if you get deported, they give you the notice. That means you're subject to the bar. There's an inadmissibility ground. You can't file for a green card if you've just gotten deported, unless you have a waiver, unless there's other stuff going on. So that's a good question you need to know the answer to. Have you ever held lawful permanent resident status, which was later rescinded, meaning it was canceled or something bad happened to it? Have you ever been granted voluntary departure by an immigration officer or an immigration judge but failed to depart within the allotted time? Okay, that's always a no-no. Have you ever applied for any kind of relief or protection from removal, exclusion, or deportation? Like you may have applied for a green card already. You may have applied for cancellation of removal. You may have applied for asylum, refugee. You want to tell them that. Have you ever been a J non-immigrant exchange visitor who was subject to the 2-year foreign residence requirement? This is saying that you need to go home for 2 years before you can become a permanent resident if you come in on a J visa that has this type of restriction on it. So you need to know that because you're not going to be able to get a green card until you go home for 2 years. If you answered no to 24A, complete items 24B and 24C. So 24A we would say no, then skip to item 25. So, but if you've said yes, have you complied with the foreign residence requirement? Have you gone home for the 2 years? Or have you been given a waiver, right, from the Department of State? So one of those will apply to you. Now we get into criminal acts and violations. This is tough. For item numbers 25 through 45, you must answer yes to any question that applies to you, even if your records were sealed or otherwise cleared, or even if anyone, including a judge, law enforcement officer, or attorney, told you you no longer have a record. Let's just stop right there. The Constitution has a Supremacy Clause that applies to the federal government being able to discard the lower state government laws when they want to. So if there's a conflict between the two laws, the federal law was going to prevail. That's called the Supremacy Clause. Not always, but this is what we're talking about here when we say your state court may have said your records are expunged. You don't have a criminal record anymore. Your state court may have said, when you're applying for jobs, you don't have to say that you were convicted of a crime because you've gotten this expungement, right? On and on and on. Your case was dismissed. You don't have a record. Your case is dismissed. State courts are going to say that kind of thing, and state lawyers are going to tell you that in a criminal context. But in a federal context, it's not going to work anymore. You have to tell them everything that's happened, all right? And so then with that perspective, you're not making a misrepresentation. It's really, really, really tough when you go by state guidelines and say, they said I didn't have to say that I was convicted of a crime. And then you say that in this federal, and then they hit you with a misrepresentation. So very important point to get across. And if you have any questions about that, you need to talk to a lawyer. You must also answer yes to the following questions: whether the action or offense occurred here in the United States or anywhere else in the world. Okay, that's pretty clear. If you answer yes to item 25 through 45, use the space provided in Part 14 additional information to provide an explanation that includes why you are arrested, cited, detained, or charged, where you were arrested, cited, detained, or charged, when, the date the event occurred, and the outcome or disposition. For example, no charges filed, charges dismissed, jail, probation, community service, whatever that is. So there's a little format for the information that you're going to provide regarding this, right? So when I have clients with a lot of criminal backgrounds, we'll make a chart. And we'll have the crime, and then we'll have just all the information about it broken up in a chart, rather than using the little addendums to the end of this form. So, have you ever been arrested, cited, charged, or detained for any reason by any law enforcement official, including but not limited to any U.S. immigration official or any official of the U.S. Armed Forces or U.S. Coast Guard? All right. That's pretty clear. Have you ever committed a crime of any kind, even if you were not arrested, cited, charged with, or tried for that crime? All right. So this one is around, this one has a lot to do with like marijuana use, because you can be smoking marijuana. It might be legal in the state where you are, but if you smoke marijuana and it's a federal crime, then you are committing a crime and you're not being arrested or charged for it. And it is a very serious thing under federal guidelines. So if you say yes to this, have you ever been arrested, cited, or detained for any reason? Were you ever committed a crime for which you've not been arrested, cited, or charged with, or tried for that crime? When you make an admission that this has happened, they're going to say that it is the same as having committed the crime and being convicted of it. So you're sealing your own conviction if you have to say, yes, I did commit a crime for which I've not been charged. So if that's your situation, you probably want to talk to a lawyer about that, because you need to handle that with a lot of nuance, and you don't want to, you don't want to make things worse for yourself. You definitely don't want to go into a place where you're making a misrepresentation. You're not being truthful, being factual to the government. We got to be truthful and factual to the government. Have you ever pled guilty to or been convicted of a crime or offense, even if the violation was subsequently expunged or sealed by court, or if you were granted a pardon, amnesty, a rehabilitation decree, or other act of clemency? So here they're going in more details about that. Ever been ordered punished by a judge or had conditions imposed on you that restrained your liberty, such as prison sentence, suspended sentence, house arrest, parole, alternative sentencing, drug or alcohol treatment, rehabilitative programs or classes, probation or community service? See how wide they are going with this? So that would be ordered punished by going into probation or something like that. Ever been defendant or accused in a criminal proceeding, including pretrial diversion, deferred prosecution, deferred adjudication, or any withheld adjudication? They want to know all of it. Have you ever violated or attempted or conspired to violate any controlled substance law or regulation of a state, the United States, or a foreign country? Okay, so there you go. And this one here, attempted or conspired to violate. So if you attempted to do a controlled substance, but it didn't work, you might still be in trouble. Have you ever been convicted of 2 or more offenses, other than purely political offenses, for which the combined sentences to confinement were 5 years or more? So this is another ground of inadmissibility. Now there are waivers for these types of things, but this is just narrowing the focus on these grounds of inadmissibility. Have you ever illicitly, illegally trafficked or benefited from the trafficking of any controlled substance, such as chemicals, illegal drugs, or narcotics? Right? And then have you ever knowingly aided, abetted, assisted, or conspired, or colluded in the illicit trafficking of any illegal narcotic or other controlled substances? And then, are you the spouse, son, or daughter of someone who's done that? Have you ever engaged in prostitution, coming in the United States to engage in prostitution? Ever directly or indirectly procured a prostitute? Have you received any proceeds or money from prostitution? And then, do you intend to engage in illegal gambling or any other form of commercialized vice, such as prostitution, bootlegging, that's alcohol, making alcohol, or the sale of child pornography while in the United States? Have you ever exercised immunity to avoid being prosecuted for a criminal offense in the United States? Ever, while serving as a foreign government official, been responsible for or directly carried out violations of religious freedoms? Have you ever induced by force, fraud, or coercion, or otherwise been involved in the trafficking of persons for commercial sex acts? Have you ever trafficked in a person into involuntary servitude, including peonage, debt bondage, or slavery? Trafficking includes recruiting, harboring, transporting, providing, or obtaining a person for labor or services through the use of fraud, force, or coercion. So trafficking is broad. People don't realize sometimes they're being trafficked, and they are being trafficked. And so this is what it looks like. Have you ever aided or abetted in trafficking anyone? Are you the spouse, son, or daughter who is engaged in trafficking people? Have you ever engaged in money laundering? Or have you ever knowingly aided, assisted, conspired, or colluded with others in money laundering? Or do you seek to enter the United States to engage in such activity? Well, President Trump is definitely engaged in money laundering. And so he should actually be deported. I think we need to deport President Trump for money laundering. Don't you think so? Security and related. Do you intend to engage in any activity that violates or evades any law relating to espionage, including spying or sabotage in the United States? So, of course, spies aren't going to say this as they're coming in, right? But they ask these questions because when you make a misrepresentation and you do it later, here's another. You can go to jail for espionage, and then when you get out of jail, you got to be deported. And then you've got this question answered as a misrepresentation on a form before immigration, which is another deportable offense. Trust me on this. This works a lot. But security grounds, there's not a lot of waivers available for any of these types of security grounds. So read through them. If you have to say yes on any of the security grounds, you're going to need a lawyer. Absolutely. And there are some waivers available. We'd be really creative in getting some of these waivers. When you're a member of the military, a lot of times you will have, some of these you have to say yes to some of these, like this one here. Have you ever received any type of military, paramilitary, or weapons training? Yeah, I was in the military. So it's not a death sentence for you, but read through them. And if you say yes on the military training, they're going to ask you for information on your military training. So you can expect to receive, or you should expect to provide them with, the information on your military training, where you were, the dates you were there, what your status was, what your rank, when you were discharged, that type of information. Provide them that. If you don't, they're going to ask for it, and so it'll delay your case. So I'd like to get all that stuff and provide it up front and then bring it to the interview with you. And then we get into more here. If you answered yes to any part of items number 46A through 50, explain what you did, including the dates and location of the circumstances, or what you intended to do in the space, or what you intend to do in the space provided. Part 14, additional information at the end. Are you the spouse or child of an individual who ever did bad things like that? Okay, so there's all those. If you answered yes, explain the relationship and what occurred, including the dates. Okay. And then we're going into more. Selling, providing, transporting weapons. And then there's this one. Have you ever worked, volunteered, or otherwise served in any prison, jail, prison camp, detention facility, labor camp, or any other situation that involved detaining persons? And then groups using weapons, military groups, Communist Party, Nazi Germany, torture, killing, intentionally severely injury, engaging sexual contact, relations with any person who did not consent or was unable to consent or was being forced or threatened, person's ability to exercise religious belief, recruiting children soldiers. If you answered yes to any part of item numbers 52 through 60, explain what happened, including the dates and location of the circumstances. So you definitely want to get a lawyer in on this stuff. Now, public charge. Public charge meaning you're going to be a burden on our society financially. Those who are subject to the public charge ground of inadmissibility under INA Section 212A4 must complete Form I-944, Declaration of Self-Sufficiency, and may also have to submit Form I-864, Affidavit of Support, under the Section 213A of the INA. So yeah, not everyone who files for a green card has to deal with public charge. Some green card categories, you don't deal with it. But for ours, spouse of a U.S. citizen, absolutely, you're going to have to deal with the affidavit of support. So we have the Declaration of Self-Sufficiency, Form I-944. Are you exempt from the public charge ground of inadmissibility? All right, so we're going to be saying, no, I'm not exempt, I'm subject to it. To determine if you are exempt from the public charge ground of inadmissibility and therefore exempt from filing Form I-944, read the Form I-485 instructions, which we did. What evidence must you submit? Which is interesting because they're geared qualifying you for the I-944 here on the I-485. We'll also go to the 944 and we'll look at that form where you also qualify. Affidavit of support. These are the categories for I-864. These two forms work together. And you might be exempt because you've received credit for earning 40 qualifying quarters of work in the United States, defined by the Social Security Act. Well, very rare that someone in this situation is going to have that. Under 18 years of age, nope. Applying under the widower category, okay, so that might be. But mostly, none of these are going to apply to a spouse of a U.S. citizen. I'm applying for the victim of qualifying criminal activity. Okay, right. Under U, so U's don't usually have to show affidavit of support information. And then here's more questions on the U, which is not really relating to us. Other special categories, diversity visa, Immigration Act. Okay. Now, so that's the public charge issues. Illegal entries and other immigration violations. Have you ever failed or refused to attend or to remain in attendance at any removal proceeding filed against you on or after April 1st, 1997? This is when the law came into effect. I started doing immigration law in 95, and I remember when this came into effect. And so you're going to probably say no to that, hopefully. If your answer is yes, attach a written statement explaining why. Okay. Have you ever submitted fraudulent or counterfeit documentation to any U.S. government official to obtain or attempt to obtain any immigration benefit, including a visa or entry into the United States? Here's our false documents ground of inadmissibility. So a lot of my clients who marry U.S. citizens are here working illegally. Sometimes they might have a fake green card. Sometimes they might have a fake Social Security card. And they buy them at the swap meet, or they buy them at the little tienda, the little store, and they go and use that document and give it to an employer so they can work. Okay, so if you do that, to any U.S. government official is the name of this game. So if you're giving it to an employer, you can answer no here because you're not giving it to a U.S. government official. Okay, so I just want to get that clear. Have you ever lied about, concealed, or misrepresented any information on an application or petition to obtain a visa, other documentation, or any other kind of immigration benefit? Right. Lying and concealing is always bad. That's why. Have you ever falsely claimed to be a U.S. citizen in a writing or any other way? All right. That's a death knell for sure because there's really no waivers for false claim of U.S. citizenship. Stowaway, and then foreign smuggling people. All right. And then here's another document fraud. Are you under a final order of civil penalty for violating INA Section 274C for use of fraudulent documents? Right? If you'll know that if you've got that for sure. Removal, unlawful presence, or illegal reentry after previous immigration violations. These are the whole category of this. We have the excluded, deported, and removed, ever enter illegally. All right. And then since April 1st, 97, have you been unlawfully present in the United States? Look at this. For more than 180 days, just 6 months, but less than a year, and then departed the United States. If you say yes, that means you're subject to a 3-year bar to reentry. So if you come back before the 3-year bar runs, that's a problem, right? Or been unlawfully present in the United States for more than a year and then departed and left the United States. So if you're applying for adjustment of status and you left and came back, there could be a problem with that. There's grounds of inadmissibility. But there are waivers available as well. But you're going to talk to a lawyer about this if this applies to you. No, you were unlawfully present in the United States if you entered the United States without being inspected and admitted, or inspected and paroled, or if you legally entered the United States but you stayed longer than permitted, right? And that's true. So that's the definition there. You can apply to those. And then since 97, have you ever re-entered or attempted to re-enter the United States without being inspected and admitted or paroled after having been unlawfully present in the United States for more than 1 year in the aggregate, or having been deported, excluded, or removed from the United States? So if you have to answer yes, there's these bars, again, that to keeping you from getting your green card that you're going to want to talk to a lawyer about. Because there are waivers for these things, but some of them don't have waivers. Some have permanent bars. So you need to know the real deal on this. Okay, miscellaneous conduct. Do you plan to practice polygamy in the United States? Are you accompanying another foreign national who requires your protection or guardianship, but who is inadmissible after being certified by a medical officer as being helpless from sickness, physical or mental disability, or infancy as described in INA Section 232C? Have you ever assisted in detaining, retaining, or withholding custody of a U.S. citizen child outside the U.S. from a U.S. citizen who's been granted custody? Ever voted in violation of any federal, state, or local constitutional provision, statute, ordinance, or regulation in the United States? That's a bad bar. Illegal voting is bad. Have you ever renounced your U.S. citizenship to avoid being taxed by the U.S.? So I was a citizen and I didn't want to pay taxes, so I renounced my U.S. citizenship. Have you ever applied for exemption or discharge from training or service to the U.S. Armed Forces and the U.S. National Security Training Corps on the ground that you are a foreign national? So this is a good question, because if you go on to citizenship, they want you to register for the draft. And you can register for the draft if you're a tourist, if you are illegally here, if you are filing for a green card, as long as you're within the age requirements. So registering for the draft is an important thing to do if you want to go ahead and get citizenship down the road. Been relieved or discharged from training, being convicted of desertion, those are bad things. Have you ever left or remained outside the United States to avoid or evade training or service in the U.S. Armed Forces in a time of war or a period declared by the President to be a national emergency? It's a bad thing. If it was yes, what was it all about? Okay. Then we get to the end of it, where we're talking about the accommodations. If you're deaf or hard of hearing and blind and other disabilities, you can ask, you want to give them the heads up that you need support in your interview. Applicant statement, you can read English or you can't read English and you have an interpreter, and you put the interpreter's name here. And if you have a lawyer prepare this for you, prepare this application for me. If you provide your own and prepare your own, you don't need to do this. And we're thinking you're going to be preparing your own applications here. So you're the applicant, the immigrant. So applicant, phone number, email, applicant certification. Look at this. I understand that if I'm male who is 18 to 26 years of age, submitting this application will automatically register me with the Selective Service System as required by the Military Selective Service Act. Great. But I would register as well. So I would have my proof of registration that I could show at my naturalization interview. And what else is it saying here? Take the biometrics, that's true. And then you're going to be sworn in, and you're going to say that everything here is true and complete and correct under penalty of perjury. Sign it. And you're going to sign this in blue ink. Sign in ink. We use blue so they can know it's an original, and date it. Your interpreter would fill their stuff out, all black ink, put the language, and then their signature in blue ink. And then me, if I'm filling it out, then I fill all this stuff out. I say I'm an attorney, or I'm not an attorney, I'm just a friend who's doing it. And then my certification and my signature there. And then the last part here is at the interview, when they're going to a U.S. officer's name here, and then the applicant will sign it. And then we have the last page here, which is where your supplemental information will go. Page number, part number, and then remember the descriptions that you give. So thank you for watching our video number 3, I-485 application to register permanent residence or adjust status. You're going to move on to video number 4 now. And thank you for watching, and we look forward to working with you on reviewing your forms and documents.